The Raising the Bar podcast, brought to you by the Association of Gray's Inn Students.
Hello and welcome to the Raising the Bar podcast. I am Nia Marshall, and today we are lucky to be joined by Mr. Richard Atkins QC, who is the head of chambers at St. Philip's Barristers. He's a bencher of Gray's Inn and is one of the country's most eminent criminal silks. Richard sits as a part-time Crown Court recorder and as a part-time fee-paid judge of the Mental Health Tribunal, and also a tribunal chair for the Financial Reporting Council. He's also one of a small number of Judicial College tutor judges who train Crown Court judges. Interestingly, Richard was the chair of the bar in 2019 and the leader of the Midland Circuit from 2014 to 2017. In today's podcast, we will be discussing remote virtual hearings. Thank you for joining, Richard.
Thank you, Nia.
Now, before we delve into the substantive matter, I'd like for you to give us an overview of your journey to the bar.
Certainly. I don't have any legal background. My father had a shop in Coventry that sold spare parts for domestic appliances, washing machines, vacuum cleaners. My mother was a school teacher. I did pretty well at school, and when it came to deciding what to do at university, I decided to do law. I don't really think I knew what else to do. I had a slight hiccup to begin with. I was rejected by 4 of the 5 universities I applied to, so I reapplied and got lucky a second time around and went off to read law. I was initially thinking of joining the Royal Navy, but decided I'd get a qualification first, so decided to apply for the bar. I think back then, when solicitors didn't have rights of audience, I thought that I didn't want to be the person sitting behind the advocate. I wanted to be the advocate. So I went off to the bar school, joined Gray's Inn, and then did pupillage in London. The plan was to then go and do a short service commission in the Navy, but I went off that idea. So I did my 12 months in London doing a civil pupillage, and then applied to Birmingham, coming back to the Midlands, where they took me on at One Fountain Court to do a third six pupillage. They put me with a criminal practitioner so that I could do some criminal work, and I'm afraid I never then moved away from doing crime. And after about 5 years, I gave up doing civil. So I started off doing smaller cases. They lead on to the bigger cases, and here we are 32 years on. Not quite sure how I've got here, but I'm a QC practicing doing crime and regulatory law.
Now, we know that you are an eminent criminal silk, but could you also give us an overview of your experience in terms of your practice areas?
Sure. Well, I started off, I did some pupillage in London. Initially, my plan was to join the Royal Navy, having done some pupillage, but I went off that idea. So I did 12 months in London and then applied back to the Midlands, from Coventry originally, I think I've already said. And I had a third six pupillage at One Fountain Court. I did civil work for about the first 5 years, having done a civil pupillage in London. But they put me, when I moved to Birmingham, with a criminal practitioner to do a little bit of crime and get some experience of advocacy. And I'm afraid it stayed with me. My pupil master is also in silk, and we do cases together now, which is delightful. But I started off doing small criminal matters, and then you build up as you go. I'm not quite sure where 32 years has gone, but you work your way through the ranks and suddenly find you're in silk and leading in the bigger cases. So I have what I describe as an F-word practice: fraud, filth and fatality. So death, sex cases, fraud cases, and I also do regulatory work, health and safety and trading standards.
Interesting indeed. Now, we do know that COVID has had a significant impact on the justice system, and it actually has introduced the use of remote virtual hearings. Now, let's start with your thoughts on remote virtual hearings.
Well, Lord Justice Leveson had done a review prior to COVID and had indicated that we should all be using technology more. So I had actually done a few remote hearings using the telephone. We weren't really using video links very much. I'd done a couple of hearings where I've been dealing with a terrorist case, and I was in Birmingham and they were being operated from the Old Bailey. But all of a sudden, come March of last year, we were suddenly forced into adopting all of this technology. I was actually sitting as a recorder in the Crown Court in Worcester, and we went into lockdown. And I went from the Monday when I had people in front of me and in theory we were about to start a jury trial to the next day when we were told no one's coming. So we were forced into this position of having to find a way round, certainly in the criminal courts. And we've had to adapt and adopt. We tried all sorts of things to begin with. I say we, the powers that be. There was Skype, there were telephone hearings. Now we're using the cloud video platform, and it's forced us to up our game. And I think it's been a good thing. It doesn't work for everything, as I suspect we'll discuss in a short while. But it has meant that we've moved on in leaps and bounds, and we're able to do a lot more than we would ever have thought of this time last year.
How did you feel initially moving into, I guess, immersing yourself more into these virtual hearings? Was it a feeling of being overwhelmed?
No, I was fortunate because, as I say, I was actually sitting that week as a judge. So I'd got people who were able to help get the kit set up, and I was trying any way I could. I sent out messages to the clerks in the Midlands so that they knew if people were in front of me, I was not expecting to see them in court the next day, because I think a lot of people panicked and worried about what they should be doing. And I said we'd use whatever technology we could. So I said I would use the telephone. We potentially had Zoom, although it was then decided that we couldn't use that as a platform. And we used what we could. And I did hearings where I had a defendant who was in prison up on the screen. I had advocates on the remote telephone link, and I was effectively acting as the go-between at that stage, where the advocates were telling me something, I was repeating it so the defendant could hear what was happening. And it was sort of boxing and coxing, and we got through it. From an advocate's point of view, of course it was scary because we all needed to have the right amount of kit and make sure that it all worked. I know that I had a problem in my house, my study. The Wi-Fi link struggled for a while, so I've had to remedy that. And I was moving around the house to find the best Wi-Fi signal I could. But it was a challenge. But if we wanted to keep working, which of course we all did because we wanted to keep earning, we had to meet the challenge.
Now, what did you find were some of the key technological infrastructure that needed to be implemented before permitting these remote hearings?
Well, I think the big thing is that you have to have a Wi-Fi connection that works. That's the biggest problem, and a laptop that can cope. I've actually just upgraded. I decided that I needed a more powerful laptop. I'm fortunate because I'm in a position where I could afford to go out and buy one. I know that some of my colleagues are not as fortunate, and particularly those starting off at the bar may not have the resources to go and buy the best piece of kit. But I think that a lot of IT technology now has improved massively, and so people are able to use the CVP or Skype or whatever, and their computers are now much more able to cope with what's being thrown at us. So it's really, I think the biggest issue is broadband width, and making sure in my case last year that my son and daughter, who were both at home, were not busy downloading things at precisely the moment I was trying to make some representation to a Crown Court judge.
Very practical considerations indeed. Now, switching to you putting on your judge hat for a little bit, what are some of the considerations that you found that you had to assess before determining whether to permit a remote hearing? Now, I know you started to speak about Wi-Fi and broadband width, but surely there are some other considerations as well.
I was having to deal with this in the very first week of lockdown. I think things have moved on, and of course, I only sat for a short period of time then. So the biggest problem that the courts faced from a judicial point of view was how on earth they coped in a criminal world, which is my world, with dealing with jury trials, which I'm afraid came to a complete halt at that point. I think the biggest thing, if we move away from the technology itself, the most important thing is the interest of justice. And can justice actually not only be done, but be seen to be done remotely? So we've had to work our way around the various problems that has thrown up. For my part, I'm very happy dealing with as many hearings as I can remotely. Applications, pre-trial hearings, in my view, can largely be done using the technology. As I said before the COVID issue, I'd also argued various cases on the telephone when I'd had a case in the magistrates' court, and also on the link when I was dealing with a judge who was sitting at the Old Bailey at the time, and I was up in Birmingham. I think it's more complicated to do a jury trial fully remotely. I don't think it's been tried. I have been fortunate since September that I have been able to do a number of trials. I've actually physically been in court to do them, but we have had witnesses over the link, although they tend to be experts rather than witnesses as to fact. And I'm not sure myself at the moment that the technology is good enough to have witnesses as to fact really giving evidence and having the whole thing done remotely. I think jurors still need to see majority of witnesses in court. Although having said that, we have had now for many years the situation where complainants in rape cases or vulnerable witnesses give evidence, although they're at court, they're in another room and they're on a link. But that often tends to be better than the Wi-Fi system and setup.
Now, you made an interesting point referencing justice, and it made me start to think about parties who are involved besides advocates, and how this process would have impacted them in terms of their access to technology and dealing with distractions as well in some persons' homes. How do you think this would have impacted upon them?
I think that initially the thought was that we would only be allowing people to watch what was going on if they came to court, if we're talking of members of the public or members of family members of either victims or defendants in cases. And so a number of Crown courts had a setup or a system set up where they would have the judge and the jury in one court with some of the advocates, perhaps some of the defendants and some of the advocates in a second court that would be linked in, and then a third court available for those who wanted to view what was going on. But of course, the backlog of cases that we're having to try and overcome has meant that the courts are trying to use as many courts as possible. And I know that in a case I've got coming up shortly, what is anticipated is that those people who want to view what's going on, so families of the defendants or family of the victim, will be allowed to join in remotely from their own homes. Now, of course, the problem is that we're not allowed to record Crown Court proceedings, so people have to be told that and hope that they abide by it. You also have to have it spelled out very clearly that they need to understand where their mute button is. In a case I did recently in front of a High Court judge, we had, I shan't name them, but some people who should probably have known better, professionals who were listening in, who didn't manage to hit the mute button. And all of a sudden, midway through a witness, a kerfuffle started when somebody walked into the room that these people were in, started chatting away, and of course they were oblivious to the fact that it was now broadcasting all over the Crown Court proceedings. But I think we are now reaching a point where interested parties are going to be allowed to link in and can watch, so that we don't exclude the victims' families or the defendants' families. And it may be that the families of the defendant haven't had very much opportunity of seeing their loved ones because they've been locked up for many months and for far longer than they would have been had we not been in this COVID times, when I know that prison visits are blocked. So they're desperate to see what's going on.
I know that sometimes it can be hard to imagine that there are some of us who are less fortunate and don't actually have access to Wi-Fi or the relevant technology to tune in. How do you think the court actually goes about dealing with those parties so that they can also to be involved in viewing those proceedings?
Well, I think if it's the families of the victim or victims, the police and the Crown Prosecution Service will do their level best to ensure that there's some way they can watch what's happening. It's different if it's the family of the defendants who are on trial, but I know that a number of solicitors' firms have managed to make space available and supply or allow people to use their equipment, although that doesn't always work. I suspect that most people nowadays have access to some form of computer equipment, whether it be a mobile phone or maybe an iPad or something of that nature. So most people, I think, are able to view what's going on. And I think everyone tries their hardest to ensure that those who perhaps don't have the equipment can, a way will be found that they can participate. But it's not easy. I mean, it's the same. I know from my experience of having children that some are fortunate and have computer equipment that they can use to carry on their studies, and others there may be a number of members of the family all trying to use the same piece of equipment. So it's something we have to look at and be mindful of.
Yes, I very much agree. And turning to the role of the court in all of this, does the court actually arrange the remote virtual hearing?
Well, in the Crown Court, we use what's called the CVP, the cloud video platform. You have to have used Google Chrome rather than any other brand on the market. But you will be sent a link which you click on, and then that gets you into a waiting room, and then the court invites you in and can obviously shut you down and exclude you if it needs to. So you don't actually need anything other than the ability to get online and have Google Chrome downloaded on whichever device you're using. It's overcome the problem that we were having with people not having, for example, Skype or Zoom or Teams, which they would have to have purchased or downloaded themselves. This is just a click on a link and you're in.
That seems very helpful. So would you say that then in a criminal context, is CVP then used largely? Are there any other platforms that the courts utilize?
Well, that's the only platform that I'm aware they're using at the moment. They tried various others. In other jurisdictions, I think they've been using Skype and they use Teams. But in the criminal courts, it's this CVP that's being used.
Now, I know we spoke earlier about some of the challenges in terms of internet connections during a hearing, but how do you find those challenges are addressed when a hearing is actually taking place in terms of time lapses and unavoidable interruptions as well?
I think to an extent you have to go with the flow. It would be very easy to get very cross about a whole raft of things. I also sit as a mental health tribunal judge, and that can have its complications because sometimes you're dealing with people who find it very difficult to control their actions or emotions because of the particular problems that they have. And I've had a number of cases where people have switched off the equipment, even though they're in a room with other professionals. And you can't get cross because, on the whole, this isn't really their fault. In the mental health world that I operate in, it's often the unfortunate consequences of the illness that these poor people are suffering from, which isn't their own fault. In the criminal courts, of course, you have to, it's a much more formal process, and the judge has to ensure that you don't have people disrupting what's happening, but you have the capacity there to mute somebody or to actually shut them out of the hearing. In terms of actually dealing with somebody, a delay can be a complication. You do have to adapt your advocacy, I think, and you have to make sure that questions are short and that you pause and you wait until the witness has then answered the question. The difficulty, of course, is that if a witness is straying from the path that you want them to be on, if you're in court, you may have much more control because you get much more of a feeling of what's happening. You can pick up on body language. If I'm an advocate, I can put my hand up to sort of stop somebody. the way the system is set up in most of the Crown Courts is that you have a very big screen on a wall that's a considerable distance away, and the camera is on that screen looking at the advocate, and you may then be quite a small person in the view of the witness. The witness will be sitting in front of their own technology. So, as I'm sure we're all familiar with Zoom or Teams or whatever now, your face fills the screen, whereas in court, the advocate is many meters away. And so you lose some of the interaction, and you lose some of the body language, and you lose some of the ability to control what's happening. So you have to adapt your advocacy to cope with that.
And from your experience of sitting in these hearings, do you find that generally the norm is that people will conform to these new standards?
I think so. The bar always adapts. We've had all sorts of things come along and be thrown at us, and we get on with it. And I've been doing training with Gray's Inn. I've spoken to our students and new practitioners and given tips and guides as to what I think works now that we have to work remotely. So I think the advocates have to adapt, because if you don't adapt, then the courts will say, well, we're not going to run these hearings. And of course, in this COVID lockdown, if we're not actually coming to court, we're not being paid. So there's an incentive for most members of the bar to conform and to get to know how to operate all of their equipment. As I said, really the witnesses who have been giving evidence remotely, on the whole, in my experience, have been expert witnesses in these cases. So they know what they're doing, they will log on. I did have a problem in a case I've just finished where the expert had a problem with his microphone, but we just had to take it gently. And although it was irritating, there was no point getting irritated, and the judge dealt with it very well. And we just had to slow down and keep reminding this particular chap that he'd got to speak into his microphone rather than turning away. We haven't had the position where we've had people who might be disruptive, because most witnesses are still appearing at court with all the safety provisions brought in, and defendants will be at court and giving evidence in court. So if there's any chance of disruption, you've got the judge on hand to keep a fairly tight rein on things.
No, I think one thing is absolutely clear for members of the bar, or persons who are hoping to be members of the bar. We do need to remain resilient and willing to adapt. Now, I'm sure that these remote hearings do have some benefits. Do any of these benefits come to mind?
Well, in the past, we always had to appear in court. So I live in Birmingham. If I were instructed to appear in a case at the Old Bailey, I was up at the crack of dawn on the train, and it was only a mention. So I'd be travelling for, say, 3 hours, costing me several £100 potentially to turn up to do a mention and then to get back on the train and go to Birmingham. Now I can roll down to my study, I can do some work until the allotted time. I can appear at a remote hearing, a directions hearing, for 15 minutes, 20 minutes, log off and be at my desk already and able to carry on and do other cases, or to prepare other cases. Or I can appear in different courts on the same day, because I'm able to, my clerks are able to get me a time marking. So I can have a 10 o'clock hearing in Birmingham remotely, and an 11 o'clock hearing in Coventry, and a 12 o'clock hearing in Nottingham or whatever. Personally, as a silk, I don't have quite that many cases, but for the juniors who will have a number of cases on the go, I suspect it's much easier and much cheaper for them to be doing it this way. And for my part, I very much hope that once we've beaten COVID, we don't go back to the idea that you travel for several hours and get charged a lot of money for petrol, parking, train fare, whatever, to do a 15-minute hearing. I think we have to embrace this technology. As I say, I'm not sure that it's going to enable us to do fully remote trials, because I'm not sure that really a jury trial is quite kitted up for that, but we can use it to our advantage.
Definitely seems more convenient and less expensive, especially when you so helpfully gave us your typical scenario or example. Now, I'm sure as well that there are some cons or some disadvantages of these hearings, because I have noted that you stated that obviously all hearings can't be remote. Are there any other disadvantages that do come to mind?
Well, I think one of the problems, one of the things that worries me slightly, is that the way that the bar has traditionally worked is that the very junior members cut their teeth by picking up returns from the more senior members. And when I was starting out, a more senior member couldn't be in Coventry at 10 o'clock and Nottingham at 11. So they made a decision and they would do the more important case, and the less important case would be given to somebody more junior. Now, this remote way of working does allow people to look after their own cases and make sure that they service them. But it means that the crumbs then aren't falling from the tables for the more junior people to pick up and other cases. So my fear is that whilst it is helpful to many, those who are trying to establish a practice will have a harder time doing it because they're not going to pick up the returns that when I started out in the early 90s were a regular part of life at the bar. So people are going to have to adapt. My fear is we might see a shrinking of the bar. Having said that, with the backlog of trials that we have, I think when we can actually get all the trials up and running, there's going to be a lot of work and people are still going to be needed because we're not going to be able to service all of our own trials when they're trying to get rid of the backlog.
That's definitely some food for thought. Now, in terms of advocacy, online advocacy, do you think that advocacy potentially changes when utilizing these online platforms?
I think it does. I think, as I say, you have to slow down. I think that was one of the biggest lessons I learned when I was being led on one occasion, and my leader many years ago now let me do something. He said, just slow down. And it's something that takes a while to get used to. But with the technology, you really do need to slow it down so that people understand. You may not be able to see the judge's pen. That was always a reasonable indication of how well you were doing. So that's the first thing. You need to get your kit set up so that it looks as though you are actually looking at the witness. This is one of the things I've said when I've been doing the pupillage and new practitioners training, either on circuit or for the inn. If I am on a remote hearing, I ensure that I operate several screens, but I make sure that the screen and the camera that I'm looking into enables me to look pretty much straight into it. And I have a second screen immediately behind where if I'm reading something, I have the words just above the camera on my laptop. So it looks as though I'm looking straight into it. I've said to a number of people, for example, that they may have their camera mounted on a screen at an angle, and then they're looking at a screen on their laptop in a different way, and it looks distracted. It looks as though you're not really paying attention. So you have to adapt and make it appear that you are talking to the person, even though what you're actually talking to is a little pinprick of a camera on your laptop screen. I've actually heard of somebody who has cut out a little face of a judge and stuck it over the camera so that they are actually looking at the judge and addressing the judge, because it gives them something to actually look at and talk to, which isn't a bad idea. It reminds you of what you're actually meant to be doing.
Definitely. I think some of us are going to have to take that little tip as well. Do you have perchance any do's and don'ts as well for performing online advocacy?
I suppose it's make sure you're ready. Always have a look over your shoulder, because I've seen some absolute howlers with people having suddenly had to move because their Wi-Fi's crashed in one room and they've rushed into another room, and what's over their shoulder is their underwear hanging over the end of the bed or something like that, which of course is completely distracting to anyone else looking. So make sure that you're in a quiet area. Make sure that you've locked the dog out if necessary. The children know they're not meant to be coming in or suddenly playing on some game. make sure that it's a reasonable backdrop behind, and make sure you find out whether you're actually on a camera hearing or whether there's no camera. Because I've also heard of some howlers where people have sort of wandered in almost in their pyjamas and then link in thinking it's not a camera hearing, and suddenly find that they're being broadcast and having to slink out very rapidly and grab a jacket and tie. And if you're one of those people who wears the jacket and tie but is wearing something different on your lower half, just remember that when the court usher says court rise, you don't stand up, because you suddenly give the game away that you're still in your pyjama bottoms.
Definitely some helpful practical tips there. Now, I know that we were speaking earlier about witnesses, and I know you were making reference to the fact that advocates have to be aware that they need to slow down as well. How else do you think witnesses are managed effectively when in this online setting?
My own view is that it's the judge who really should take the lead. And when I am dealing with my mental health tribunal cases, initially, before the video platform came on, we were doing them on a telephone link. Now, that was really quite difficult because you couldn't see people, and you'd have people in all different locations. But I would make sure that I explained to everybody that they would all have their turn, that the patient whose application it was could go first, give us their evidence, and I would come back to them and hear from them in due course. I think the same applies when you're on a video link hearing. I think the judge needs to set the ground rules to make it clear who speaks and when, and that people will be given an opportunity of saying their piece at the appropriate time, and just firmly, gently but firmly, making clear that this is a court of law. It's important that we hear what everybody has to say, and we do it gently. So I try and put people at ease if I'm sitting as the judge. Equally, if I'm the advocate, you can't put everybody at their ease, because sometimes you've got to try and take people apart if you're cross-examining them. But you don't need to be unpleasant, and you try and do it as gently as possible, as slowly as possible, but making it clear that whether you're the judge or the advocate, you're a person in authority, and the person who you're questioning just needs to listen and answer the questions.
Now, do you think that the remote attendance of witnesses actually cause issues or potential issues regarding credibility?
It's difficult, isn't it? Because I think the traditional view of the bar is you need to see a witness and you can tell whether they're lying, and jurors need to see witnesses and they can see what's happening. But of course, that ignores the fact that there are many blind people who serve as jurors who, of course, can't see the witness, but they can judge what's happening. You can hear, you can listen, you can evaluate. So I suppose it's almost an element of unconscious bias. Our initial thought is, well, if we don't see them, how can we, if we don't actually see them in the flesh, how can we actually really evaluate? But we started many years ago having vulnerable witnesses and complainants in sex cases and children give evidence, as I said, remotely, although they'd be in a room at the court, just not in the courtroom itself. And jurors are able to assess witnesses, judges are able to assess witnesses. So I don't think it's as big a problem as we thought. But of course, I don't know whether it happens. I did have a case recently where I was midway through cross-examining somebody, and then a link of somebody viewing went down. Now, afterwards, I thought, crumbs, did that go down? And they asked to just pause proceedings, because I was actually doing well with the person who was their witness and denting their credibility. I think that's probably a cynical view, and I don't believe that was what was happening. But you have that potential that somebody who is having perhaps a tough time might suddenly pull the plug or knock water over the laptop, which wouldn't happen in court. But I don't think it's happening, and I think on the whole, things are working pretty well. But I think you just have to be aware. The judge has to be aware, the advocates have to be aware, and if somebody thinks something isn't working, then they just need to raise it with the judge. So I think we just have to be alive to the various complications. But as I say, I think it's the technology still, I don't think, is quite up to having a position where every witness could be dealt with remotely.
Now, on the back of that point, then, where do you think the line should be drawn between when witnesses should be allowed to attend remotely and when they should be compelled to attend physically?
I think it depends on the evidence they're giving. I think it depends on the nature of the case. I think it's still important that we have people come to court and are seen and appear in court on the whole. But I've called witnesses in cases who've been abroad. So I prosecuted a large fraud a few years ago, and I had a witness who went along to a hotel. They set up a camera and he gave his evidence. And actually his evidence was clearer on that link from India than some of the links I've had from prisons sort of down the road. So it can work, but I think the technology still has the potential to let things down rather more than we would like. So as the technology develops, then yes, we may move to more remote hearings. But at the moment, I still think on the whole, in a trial where someone's liberty is at stake in a criminal court, on the whole, I think we really need to have as much done in court as we can manage. But if it means that you have an expert who can give expert evidence over the link and can do it, it doesn't work for everybody because some people need to demonstrate things and show things. But if it's somebody saying, well, I examined the body and I examined the bones and the bones had fractures, then they can do that over a link. So it's weighing up the case itself and making a decision as to whether, in the interest of justice, really justice can be seen to be done, I think. We're not quite there yet for fully remote hearings, and I suppose I don't really want to go to that point, but partial remote hearings I don't have a problem with.
And I think that brings us nicely to our last point, where I was going to ask you, post-COVID-19, do you think remote hearings will become the new normal?
I very much hope they become the new normal for pre-trial hearings, for mentions, for hearings where you can argue the law and you don't physically need to be in court in a pre-trial setting. So I think we need to make much more use of them. It saves cost. I think it assists. It enables advocates to look after their cases. So I very much hope that we don't go back to, right, everybody now has to be at court. I think that would be a retrograde step. And if you think back to where we were 12 months ago with technology, I mean, I think I'd only just heard of Zoom at that point. Now, Zoom is something you do almost on a daily basis. So the technology, I think, will continue to improve, which will help. But as far as actual trials are concerned, I think we do need to get back into court, get the courts up and running for the actual trials to take place. So it's a bit of both. I don't see everything being done remotely. It hasn't been. I don't think that would be right. But I do think there's a lot that we can do that means that we don't have to be in court for every hearing.
And this concludes our discussion on remote virtual hearings quite neatly, actually. So thank you, Richard, for joining us today and finding that time in your busy schedule to fit us in.
It was a pleasure.
Thank you.
Thank you. Take care.
Thanks for listening to the Raising the Bar podcast. Please subscribe, rate and review. And for more information, check us out on Twitter @AGI Students.